Today, we are talking about the one thing you should never, ever do if you take a medical leave. Stay tuned for this video. This is something that might save your job. Hello, my name is Brandon Ortiz. I'm an employment lawyer with Ortiz Law Office in sunny Burbank, California. As always, I have to start off this video with the disclaimer that I am not providing you with legal advice. I'm just providing you with general information. If you have questions or concerns about your particular situation, you should contact an employment lawyer. Now, something a lot of people know is that a law called FMLA, the Family and Medical Leave Act, give employees at certain types of businesses, and I'll get to that in a minute, but it gives employees at certain types of businesses up to 12 weeks of unpaid job-protected leave. Now, certain types of businesses, the business has to be a certain size. You have to have worked there at least a year. You have to have at least 1,250 hours of service within the last year. So there are a lot of requirements that you have to meet in order to get that 12 weeks of protected leave. And, you know, most people are aware of that. But the one thing a lot of people are not aware is that even if you do not qualify for FMLA leave, under the Americans with Disabilities Act, and in California under the Fair Employment and Housing Act, you may still be entitled to unpaid leave if you have what is called a disability for purposes of the law. And disability for purposes of the ADA and employment law in California is very different than disability for purposes of, say, Social Security or for disability insurance or disability benefits. To be disabled under California law, all you have to show is that you have a medical condition that impairs a major life activity. That's it. It's a very low standard. If you have back pain and that impairs you from walking as opposed to somebody who doesn't have back pain, you're disabled in the eyes of California law. It's a very low standard. Most people actually have some sort of disability. Fortunately, most of us usually don't need a disability leave. But if you are ever in that situation where you do, it's extremely, extremely important that you have an end date on your disability leave, because the employer does not have to hold a job open forever. And this is a mistake I see all the time, right? The doctor will write you off work, but they don't tell you a specific defined period of time, you know, and the doctor, you know, in fairness to the doctor, you know, they're not experts on employment law. They don't really know the significance of them having given you an indefinite leave. However, the case law on this subject is very unfavorable for employees. And the law is that an employer does not have to give somebody an open-ended, indefinite leave of absence to recover from a disability or an injury. And unfortunately, I run across a lot of clients who, you know, the doctor doesn't put an endpoint for the medical leave, you know, and the doctor's saying, hey, you know, check with me in a month, check with me in 2 months, and we'll assess. And don't do that, because that can cost you your job. If you're going to request a disability leave, it needs to have a finite end to it. Now, the good news is that you can extend it, and then you can extend it again, and you can extend it for a very long time. However, if it's indefinite, if it's open-ending, the perspective that the courts have taken is that it's not fair to a business, you know, say to have to hold a job open for 3 years, not knowing if this person's ever going to return. And that's just an undue hardship to the business. If you liked what you saw today, please be sure to click like, click subscribe down below. If you're having problems at work or you were just recently terminated and you need legal advice, don't hesitate to give me a call, 888-37-ORTIZ, 37 Ortiz, Ortiz. The number is down below, and my website is also down below, ortizlawca.com. Stay safe.